quiet, but so I should probably start then, huh? You're looking at me like, okay. Well, greetings. It's great to see some familiar faces. It really is, and they speak so well of you to give up a spring day in February. Was it like 60 today? Wasn't it like -3, like 3 weeks ago, or something like that? So, above and beyond the call of duty, and it speaks very well of you to be educated. It's a volunteer position. The pay doesn't pay very well, but the fact that you gave tonight up to be here today to listen to some quality education from Pat speaks well of you. I'd like to call your attention to invitations in the back. They look something like this. If you haven't got one in the mail or need one tonight, they're back there by Tina and Susan. We're having road shows coming up, I think two coming up. So if you have not yet RSVP'd, please do so. Attending the road shows will give you an opportunity to see our new resources and meet the owners of the companies that we've merged with. And I do want to talk about our merger with Real Manage. The invitations say it best, I think. It says here that we are pleased to announce that Baum Property Mgmt, and I'm Mike Baum, by the way, has merged into the Real Manage family. The team endeavors to bring you a small firm feel with the technology and support that a larger firm can offer to the Illinois market. And that's really the truth. It's the same staff, same location, just more toys, more tools, resources, and you're gonna love it. Thank you to the staff back there, all you guys that came in today from working hard all day and came here tonight. Thank you to the press. This will be a YouTube video, I think. But let me talk about our merger a little bit. You know, technology changes like every hour, every day, and we have to change with it. And I've been looking to update our technology for some time. So I had about a 2 or 3 year search to find out the best match for our company. It's really important that our DNA stay the same as a small firm, and that's our thing. And quality, those are our two things. And I chose Real Manage because they're the industry leader in technology. Their websites, their software, you name it, they're the state of the art. So we have the best of both worlds, same as you might know it. Any changes that you see are gonna be for the good. I mean, really good stuff, win-win. Real Manage actually began as an IT company, and they said, well, what should we do with this? And they actually branched into this business. So they were an IT firm first. I think they have 9 designers full-time. So they're like state-of-the-art, and they looked to a profession to bring their expertise to, and it was property management. So we're one of 4 firms in Illinois that have merged with them, you may have heard. And if you come to our road shows, you'll hear much more about it, and you'll have a chance to meet the owners and see all of our new toys. So, without further ado, Pat Costello, many of you know him. He's your attorney for the most part for quite a few of you. A gentleman, a scholar. Pat is a principal in the firm of Keay and Costello in Wheaton and Batavia. But more importantly, I guess, Pat is the co-chair of the ILAC committee. That's the Illinois Legislative Action Committee. And there isn't anybody in the state of Illinois at all, by far, that knows more about the topic of changes to community law than Pat, because he pretty much writes it. So, Pat Costello.
Or opposes it. Thank you all for coming out tonight, Mike. Thank you for the introduction. I'm not sure how close this microphone is, but in a room this size, my voice usually carries. Is anyone having a hard time hearing me? Okay. So there were 2 different piles back there of material I hope you had a chance to pick up. One of them involves 2017 legislation, and one of them involves 2018 legislation. Please be aware that all of the 2018 legislation is proposed at this point in time, and we'll get to it. It's going to be really critical this year because a lot of what we're seeing in 2018 is a response to what was done in 2017. But before we start actually talking about the specific pieces of legislation for 2017, I want to talk about generically how we got here as an industry. And we actually have to go back a couple of years to 2015 and 2016. Through ILAC, through CAI's Illinois Legislative Action Committee, we were able to pass pretty good number of pieces of legislation in 2016 and 2015. We were able to oppose some pretty bad legislation as well. And in doing so, kind of established with the help of friendly representatives and senators and our lobbyists, an opportunity to really get involved in the legislative aspect, which we were on and off before that. There had been years where one change would be made to the General Not-for-Profit Corporation Act, and there would be one case involving associations. There were about 45 cases involving associations in 2017. There were a total of 40 bills that were introduced, even though they were already reduced down to one bill. And already in this legislative session, I think there's 21 bills that deal with condominium and community associations. About 16 of them are in the material that you have in front of you. So this is an area that the legislature is looking at more and more and more. Why? Constituents. More and more people live in community associations. More and more people live in condominium associations. It is affecting more and more people's lives on a day-to-day basis and the way those are governed. So what happens? A representative gets a phone call from somebody who says, well, in my condominium association, X, Y, and Z is happening. We need to change that. So then they go, they talk to somebody on the legislative staff writes something up, they introduce a bill that says something, and everyone goes, where did this come from? This doesn't make any sense. Well, it started with one person because of one complaint that they felt like they weren't getting resolved, unfortunately. In this past legislative session in 2017, we have had, 2017 is actually 2017 and 2018 is the 100th legislative session for the state of Illinois. They have 2-year legislative session cycles. So 2017 is when it started, 2018 will be where it ends. And as you might be aware, there's a primary coming up in March, there'll be a general election in November, and then next January, there'll be maybe new representatives and new state senators seated. There definitely will be new ones, and we'll start the 101st legislative session. So we still have a couple ideas hanging around from 2017. We still have some new things in 2018, and we're dealing with the same group of people. What happens often is that chairs of committees get changed in each legislative session. In 2017, the House Judiciary Committee changed its chair. Shouldn't be a big deal. But lots of bills either go like this or go like this in committee. So if you can stop a bill in committee, then it really doesn't gain momentum. Committees where they do a lot more discussions, where they have a lot more questions, where they have a lot more testimony. If you can't stop a bill in committee, then sometimes it kind of takes on a life of its own. And we hear from legislators all the time, you know, if they're sitting there voting yes or no, they might have spent 5 minutes reading the bill. They figured if it got out of committee, it must be okay. 12 people have already voted in favor of it. Who am I to say no? I see no votes. I'm going to vote yes. And lo and behold, the bill passes. And then later people go, maybe I didn't quite understand those 25 different changes in that bill. Maybe I only saw a couple of them. Maybe I didn't notice that. So committee's very, very, very important for the bills that we introduce in the legislation that affects your communities. The gentleman who is the chair of the House Judiciary Committee is very focused on condominium associations. Too much so, in my opinion. But he's got a keen focus on it. And last year, he had a keen focus on it. And his keen focus was that there's all these bills out there related to condominium associations. Let's see what I can do to jam all of these bills into one bill and get it passed. Makes sense. You know, why should we have 20 different bills all on single issues? But what he did with that is he kind of dared everybody. So I'm going to take 3 bills that you like. I'm going to take 2 bills that you like, even though maybe you don't hate his 3 bills, but you wouldn't have introduced his 3 bills. 1 bill that you like, 1 bill that you like, and 1 bill that you like, and I'm going to put them all together. And then I'm going to say, do you support the bill? Well, you want to make sure your 3 bills get passed. You want to make sure your 2 bills get passed. And other people have individual issues, so people reluctantly say, okay. And then at the end, he put in a bill that nobody liked, but he liked. And we said, no, we can't agree to that. We can't agree to that. We can't agree to that. But it was a dare. It was, well, will you oppose all of these other pieces of legislation that you introduced, you wrote, to keep this one little thing out? And on a couple of things we said yes. On a couple other things we said, I guess not. It's not that bad. So in doing so, we got a piece of legislation that ended up being a unified omnibus bill that came out in 2017. Everybody on the House Judiciary Committee agreed to it, Republicans and Democrats. It had no votes. It had no votes in the House. It had no votes in Senate committee. It had no votes in the Senate. Passed at the end of May, was signed by the governor in July without veto. And then it became a law, January 1st. And then people started reading about it December and November and started saying, what is this? How dare this happen? How did this happen? Where did this come from? Well, it had been there actually in place since April, but even some of the representatives and senators have called me and said, Pat, when did this come up? And I've said to them, you're one of the co-sponsors. Oh yeah, but I remember these three pieces that I really thought were good ideas. I didn't realize this one piece here. So we kind of had to go around with this legislation. That's kind of the generic thing. So this Public Act 100-292 passed, and it involved bills regarding both common interest communities and condominiums. How many people live in a condominium? And how many people live in common interest communities? That means a homeowners association. Okay, well, the homeowners association, I'm sorry, I left the material in my briefcase for some reason. I grabbed the wrong one. Homeowners associations had only two changes to the Common Interest Community Association Act. So we'll talk about those quickly. And it's nice because those same two changes actually ended up in the Illinois Condominium Property Act as well. So the two changes to the Common Interest Act is it amended the way you can amend your governing documents. Old governing documents like declarations or bylaws would have provisions in them sometimes, and it said needed to be approved by 2/3 or 75% of the community and 75% of the mortgage or lien holders. Well, that's never going to happen. We can mail that out every day, and the lenders aren't going to say, oh yes, I approve this. They're going to get it, they're going to file it in the garbage can. So as documents got a little bit newer, people started drafting, realizing that, and they said, you know what, either we're going to take that provision out, and most of the provisions, anyone who's gotten amended and restated governing document from my office, it doesn't say anything about mortgagee approval, or we're going to create this system where we're going to mail it to them. They can say no. If they don't say yes or no within X number of days, their consent is deemed approved. Meaning, if they don't do anything, it's going to be deemed approved. To allow, because when we told the legislature is 2/3 of the members have already said yes on this, and we're going to allow a declaration amendment to not go through because the banks won't get back to us, that's not really fair to the community. And they agreed. So that was changed in both the Condominium Property Act and the Common Interest Community Association Act to what we're calling basically implied consent for mortgagees. Please know, mortgagee means the bank, the lender. It doesn't mean the homeowners, because I get this question a lot. Does that mean that if a person doesn't vote that their consent's deemed implied? No. A homeowner still needs to say yes in order for their vote to count as a yes. It's only lien holders and mortgage holders, the banks. Their consent is no longer needed. Now they can say no, and it would still be counted as a no. But the reality is they don't respond at all. Okay? The other one that is going to affect, does anyone live in a community with less than 100 units? Less than 100 units, okay. Well then your condominiums, if your condominiums have less than 100 units, this gap counting provision does not apply to you. So there's a new section in both the Common Interest Act and the Condominium Property Act that says, and it's really important to know what this says, that the association, quote, shall use generally accepted accounting principles in fulfilling any accounting obligations under the Act. It's a qualifier. It doesn't just say shall always use general accounting accepting principles. It says generally accepted accounting principles in fulfilling the accounting obligations under the Act. So then we have to determine, before we know what we need to do, first of all, do we have 100 units? If you do, you're in that category. If you're a common interest community, does the Common Interest Community Association Act even apply to your homeowners associations? We have homeowners associations that we work with that may have 300 units, but they have a $40,000 budget. So they're exempt from all of the obligations of the Common Interest Community Association Act. But if your budget's over $100,000 or you've elected to be bound by the Common Interest Act, then it applies to you as a common interest community. What then are the accounting obligations under the Act? Well, if you look at both acts, and I've done this many times already in preparing for this and talking about it, and you run a word search for the word accounting, even account, you will find a provision in both acts that details the accounting obligations. And generically, I like to refer to it as the year-end accounting that associations are required to give to their members. What the law says is the board shall provide all members with a reasonably detailed summary of receipts, common expenses, and reserves for the preceding budget year. So we mail out the budget, and the budget's what we anticipate to spend. Then at the end of the year, we mail out the year-end financials, which detail what we did spend. And it is that mailing that must comply with generally accepted accounting principles and comply with GAAP. Your interim financial statements do not. Your monthly management reports do not. It is that year-end statement that is sent out to the homeowners. And if I can give you a little perspective as to why this came up. Our friend Steve Anderson, a representative from Geneva, introduced this bill for only common interest communities originally, for 1,000 units. So Steve's concept was, for places that are like a mini town, basically, maybe they should have some kind of compliance. Well, the chair of the House Judiciary Committee thought it was such a great idea that he came and said, you know what, let's lower it to 100, let's put it both in the Condo Act and the Common Interest Act. That's one of those things where people went, okay, I guess. Now, the idea is they're trying to create some uniformity for purchasers. So when a purchaser is comparing condominium A and condominium B, they could say, you know what, they're 3 blocks away from each other. They kind of look the same. I walk through, this is a 3-bedroom unit, that's a 3-bedroom unit. They both have balconies, they both have a parking space. Okay, well, have you looked at the financials? Because one has $3 million in reserves and the other one has $40,000 in reserves. One has not budgeted for any expenses going forward, and they need a new roof, and they need a new parking lot. And the other one has all those funds set aside reserved for those things for the next 20 years as anticipated. You're not buying the same unit then. And if the accountings can actually match up, then you can compare apples to apples as opposed to apples to oranges. And that's the concept. It's like a disclosure that a corporation or stocks would have to make through the SEC so you could actually see some kind of compliance. So it does make sense, but it's going to change the way some associations have to do it. Luckily, if you have professional management with an accountant, they understand this. We've talked to them about this. They know what to do. Talk to them about how your records need to make that compliance. They know that they will know how to do it. For a lot of associations, they've said, even if you're not getting a full audit, we can do a compilation. The compilation, even if you were on a cash basis, can get it over. The big things from what I've heard from accountants are, you have to be on accrual, you have to deal with disclosures, and you're probably going to need more footnotes than what you had previously for your financial statements because you need to have these contingencies out there. So those are the 2 big highlights for the Common Interest Act. Other than that, Common Interest Act stayed the same. There were some other changes that were proposed. They never made it in there, including one that was going to set a threshold before you could initiate collection action of $1,000. Why? Because somebody called up their state senator and said, I got sued for $40 and then they incurred $3,000 in legal fees and now I owe all this money. When I talked to that state senator, I said, I guarantee you that didn't happen. Because no one's filing a lawsuit over $40. Because if I walk into court seeking $2,000 in legal fees over $40 of delinquency, a judge is not going to give me those $2,000. And the next time I ask, I'm not going to get it. And the next time, and the next time, and the next time. Because they're going to see that that's abusive. But that's the stories that are being told to the legislature. There is a bill that may modify disclosure requirements as part of a pre-sale for the Common Interest Act that's still kicking around from last year. We'll get to that when we talk about the 2018. So let's talk about actually what happened to the Condominium Property Act in 2019. or effective 2018 and 2017. There were some good things put in there. So there's a new section 9C5 of the Condominium Property Act. If anyone went to any of these legal seminars over the last 5 years, you've probably heard the word palm, and I don't mean in relation to a tree. I mean in relation to a case that was a seminal case that really affected the way a lot of associations did business. One of the things that was talked about in Palm was the way this association that Gary Palm sued was dealing with their surplus funds. So they were just making decisions to just put their surplus in reserves. The problem they had is their bylaws specifically provided that the surplus was supposed to be returned back to the members on an annual basis. So they were violating their bylaws, and when asked about it, the president of the association said, well, I was told by the former president that he had talked to the attorney one time and that we were doing it okay. The court said, yeah, that's not enough. You don't have a legal opinion, you don't have an opinion from an accountant, and what you heard from somebody else that they may have heard isn't sufficient to even protect you from a breach of fiduciary duty claim. But it got a lot of associations and a lot of accountants thinking, and the accountants said, are we reading the bylaws? When we're doing these audits and we're doing things, are we checking to make sure that they're in compliance with their own bylaws? So then they started pushing back on attorneys and saying, are we doing this? A lot of times we'd say the bylaws don't say anything about surplus or deficit. Then the accountant would say, okay, what's the instruction? What do we do? Well, now for condominiums, we know what to do. So it says basically, to the extent that the bylaws don't otherwise provide, so look at your documents first. The board has the authority to deal with surplus. And it says, you can put them in reserves. You can return them to the owner. We're never doing that. You can credit the owner's account. Probably still never doing that. Or you can maintain it in the operating account and apply it to the next year's annual budget. So it gives the board authority. Yes, ma'am.
When you finish this, would you do a little bit more explanation on the fourth option there?
Yeah, well, I can tell you right now. So it's easy to put it in reserves. Everybody knows what that means. The accountant reports to you, okay, we had a $7,000 surplus from last year. You tell your management, okay, take the check, send the $7,000 over to reserves. You fund reserves. Remember all of this concept. You're a not-for-profit corporation. You're not supposed to have surplus. Okay, why? Because that could be possibly considered taxable income. So we don't want to have taxable income for a homeowners association. So we want to fill out an 1120H, which is probably what most of your associations do. And at the end of the day, we want to get to no income. I mean, if there's a deficit, there's a deficit, but we certainly don't want there to be income. Well, what do we do with the extra money? What if we budgeted great? What if we budgeted, we're going to spend $300,000 this year and we only spent $280,000? We have $20,000 surplus. So what they're saying is you could take that $20,000 and you can put it in reserves, or you can apply it to the next budget. Here's where it gets a little tricky when applying it to the next budget. So when do I know what my surplus is from 2017? Anyone have a guess?
After your books are finished?
April, May, September, somewhere in there of 2018. When did you adopt your 2018 budgets? October, September 2017. So if you're actually going to do that, now it doesn't say the next, it says the next annual budget. Well, I don't even know about my surplus until I'm adopting my surplus from 2017. I'm going to have to then put in my 2019 budget if I have it. And where would it be reflected? It would be reflected as income, basically. So that would be additional income that you would have had from the surplus from 2017 and 2019. And technically, if all things remain the same, and you didn't contribute more to reserves and you didn't do anything like that, you will have $20,000 of additional income for 2019 budget, which I guess could bring everyone's assessment accounts down, but I'm sure you could find a way to spend $20,000. The mulch that hasn't gotten put down for the last couple of years, the project that you were putting off, the project that you thought was maybe going to take 3 years and now you can get it done in 2 instead for the homeowners, you'll find a way to do it. Don't think of this as handcuffs. This is the exact opposite. This is a way to empower associations to be able to handle these finances so they don't have taxable income at the end of the year, and they can properly trace it through a budget. So if I go back 6 years and say, well, what did you do? You got audited, you had a surplus, from 2016 or from 2017, well, we applied it. We either put it in reserves or we put it in our operating account. So you can trace the money, so you still hit zero on an annual basis. That money actually went somewhere else. It also says that deficits can be dealt with. The one thing that it does say, like a lot of other rights in the Illinois Condominium Property Act, is it gives the board the ability to make that decision, but it gives the owners the right to petition to choose a different decision. We see that in budgeting when it's over 115, see that in reserve contributions, we see that in other expense. So if the owners have 30 days from the date of notice of this surplus contribution to object by filing a petition, 20%, a meeting will be called in 30 days, and then a majority of the owners must select a new option. This is very rarely ever happens. I have seen it happen twice. Once where someone contested a budget increase that went up 125%. Once where someone passed a special assessment to replace all the siding in the unit. The first one, they filed a petition, we had the meeting, 20% of the people voted against it, they didn't achieve the majority, the budget stayed. The other one's even a stranger story. They went out and got all the votes, they invalidated a special assessment, they did not go ahead with the siding project, they did not sign the contract, they did not get the financing. 6 months later, they passed the same special assessment. The people who were opposed to it formed a committee as appointed by the board to study the siding, and guess what? They came back with the conclusion. It was a pretty good contract that we actually came up with, and guess what? Everybody's getting new siding at this association. They really, really, really need siding. So they went through the process, they went through the procedure. My personal opinion, the board probably could have done a better job up front communicating what they were doing. And that's what the issue was. Had the board done a little bit better job communicating everything up front, they probably would have reached the conclusion later, or wouldn't have reached the conclusion later, they would have reached it early. But that same right, and we're gonna see a couple other portions in the new statute in 2019 where some of those owner petition rights have been moved. Another change is to Section 15 of the Condominium Property Act. Section 15, in the first 20 years that I practiced law, I never, ever even thought about. But Section 15 changes you hear it's happening in the city of Chicago a lot more now. It's the sale of the entire condominium association. So condominium associations that are either struggling or investor-owned or a little bit underwater are getting bought out by investors, and they're like doing what's the opposite of what they did in the late 70s. They're now converting them back to apartment complexes and generating the rent from the apartment complexes. So Section 15, there was a fear that people, because you need 75% of the people to vote in favor of it. So what happens to the other 25%? Well, all they were getting was fair market value. Well, I don't know if anyone knows about Iroquois Club over in Naperville, but there was a bunch of articles about it because that's what happened to them. And there were some people there who bought in 2007. By 2015, they were still upside down. And the fair market value, they were struggling to get them even out, and people were basically, they had no equity in their units, and they were being told, you're out. So the legislature added a couple other things. They said the fair market value or whatever the debt is on the unit. So that kind of makes sense. And they also said that any homeowner who is opposed to it and is getting voted out is entitled to relocation expenses under the Uniform Relocation Assistance Act. So they gave them some things. And it's still a difficult situation, but you still need 75% of the people to go ahead and approve it. The next 4 changes we're going to go over kind of quickly. So it moves some dates. And it works with the records request, Section 19. So somebody brought up to the legislature the idea that Section 19 is the disclosure requirements. And people could make a request under Section 19 and get documents. But the association had 30 days to turn the documents over, and it included names and other information of people. But the unit owners at various other points of the statute only had 14 days to petition the action of the board. They said, how does this make sense? So if I want the names of everybody so I can contact my neighbors to say we should really do something about it, you can give this to me on the 30th day, but my petition rights would have expired 16 days ago. So they said this is an inconsistency. We need to work on both of these things. And we'll talk about the changes to Section 19. So there are 4 main areas. It talked about If budget increases are in excess of 115%, the owners can petition. That went from 14 days to 21 days. If the contracts are entered into with members or family members of the board of directors, the owners can petition. That went from 20 days to 30 days. If there's a rule that's passed where the board eliminates proxies and just goes to ballots, the owners can petition. That went from 14 days to 30 days. And if there's a capital improvement project undertaken that's in excess of 5% of the budget, the owners can petition, and that went from 14 days to 21 days. The lead sponsor of this act, even though it's nowhere in the statute, referred to it as the Condominium Owners Protection Act of 2017. So a lot of what we're talking about here is the philosophy that boards are bad, management's next bad, attorneys absolute worst, and homeowners are being abused by all of us. We've tried to talk to the legislature and say, yes, the loud people do that. But studies by CAI nationally show that people are around 90 to 95% satisfied with the way their associations are run. And that's probably not a surprise to anyone who serves on the board, because just attend a board meeting. Nobody's there, right? Why is nobody there? We talk about all this transparency, we talk about all these rights that everybody needs, we talk about all of this, and they could exercise them all at a board meeting, and you walk into a annual meeting for 680 units, and there are 4 people there. And that's it. And because, why? Because the grass is cut, the flowers are planted, the streets are plowed, the roof isn't leaking, their assessments haven't gone up that much in the last couple of years. They're not gonna go out on a Tuesday night in February. You folks did, but most people don't. Because they're satisfied with the way their community association's being run. That's what most people do, and you can see that by attendance at board meetings. Raise your assessments 150% from last year, you'll get a lot of attendance at a board meeting, I guarantee you. Or try to enact a leasing restriction. One of those two things will inevitably get people to come out. But other than that, people are generally happy. It's the loud people who are trying to promote this philosophy. And one of the things, battles I've personally been fighting, and Mike can attest to that, is, and we'll talk about this with several statutes that's coming up in 2018, is there's this idea that these homeowners are having to pay all these exorbitant legal fees because of these things that my office is doing and other offices similarly situated. So we want to give homeowners the right to sue their association and get legal fees. And I keep telling them, do you realize that you actually want to enact something then that allows for more legal fees? I guarantee you, no lawyer has ever made less money when there's more legal fees to be gotten. So this idea that somehow this is going to stop litigation when there's more attorney's fees available doesn't make a lot of sense to me. But some of this is, the belief is that if you can recover legal fees, that litigation won't be started. Yes, then you won't collect assessments, you'll let people build whatever they want on their property, you won't enforce your covenants, you'll let vendors do whatever the heck they want to you, homeowners can scream and yell about anything and behave however they want, so. We'll see where that's going. But who has read in any newspaper articles, publications, journals, about the changes, about the documents and information that a homeowner is allowed to inspect? 2, 3, 4, 5. Okay. Well, I'm not as sympathetic as other people are, and I apologize for that if it comes off that way. But Section 19 of the Condominium Property Act was changed to do several different things. One of the things they said is 30 days is too long, especially if they only have 14 or 21 days petition rights. There's no reason you can't respond to these homeowners and tell them they can come in and inspect the records. Remember, not get the records, come in and inspect the records at their expense with their expense of copying. So they said 10 business days, and here's how that negotiation went. 30 days is what we should have. We should have 10 days. How about 20? We should have 10 days. How about 14? We should have 10 days. How about 10 business days? Okay, we'll give you 10 business days. So that's where we're at, 10 business days. And the only reason I could convince them that is I said, if you match up Christmas and New Year's sometimes, you could be cutting out a total of 6 days in that request that no one's even going to be there, and there'd only be 4 days to be able to respond to it on days where a lot of people aren't working anyway. And they said, okay, we can live with 10 business days. What it also did is the act previously said that for an owner to inspect certain records, they needed to articulate a proper purpose. And it was an undefined term. And from what I understand, there were certain associations that were abusing that. So they were pushing back on their homeowners, saying, we're not turning those records over to you, you haven't articulated a proper purpose. Well, when I was talking to legislators about this, they said, well, what are you afraid of? And I said, well, commercial purpose. We're afraid that somebody can get this information and use it for a commercial purpose. They can make mass mailings. You know, I started my own insurance agency, and now I have 300 people who I could send everything out to or sell it to somebody else. And they said, okay, well, what we're going to do is we're going to get rid of the proper purpose, but we're going to include a commercial purpose, that it cannot be used for a commercial purpose. And we're going to require that if a homeowner is going to inspect it, that they certify that they won't be using it for a commercial purpose. And we're going to encourage boards to adopt rules that says if a owner does use it for a commercial purpose, they will be fined X amount. When you think about this fine, if you're in a condominium association, don't think about $25. Because for 300 names and addresses and emails, I'll pay 25 bucks. Think about $1,000. Think about $500. Those are the types of fines that I'm recommending imposing. If you are a condominium association, I guarantee you don't have this rule. Get this rule. You need it. You get a certification. You need it. Because the homeowners who come in and inspect this, we need to be able to have the power to deal with that if they do abuse it in some way. And here's why we're seeing it get abused. Because included in the list of information that could go out to people is no longer just name and address and percentage of ownership. It's name, address, percentage of ownership, email addresses, and telephone numbers. So if you are a member of an association and you have an email address on file with the condominium association, a homeowner can come in and inspect that list and get your email address, your phone number, your address, and your name. Percentage of ownership, which they could probably see from the governing documents, but has to be listed for them. This has struck fear into the hearts of condominium owners. Now, personally, my email address is on a website. Anybody can send me an email anytime. I'm sure most of your email addresses are readily accessible if I know the town that you live in and how to spell your names. But there's a fear that people don't want to be bothered by email from the complaining person who wants them to vote for them for the board, or is sick and tired of the way the snowplower is dealing, or really thinks that there should be a new tree planted on the corner. They don't want to deal with it. My personal opinion, I don't want that person at my front door. I could delete their email and block them permanently. But this is a big, big, big concern. Part of what's concern is previously some of this information that went out, management companies, not Baum, but management companies have been representing to the homeowners that this would be kept private and never disclosed. Well, now that representation is no longer true because the act requires it to be disclosed. So some places are scrambling to deal with that. Luckily, there are 5 pieces of legislation already pending to modify this portion of the statute. So something's going to happen probably in the next 10 months that change the way this is being done. But be aware of it. And as board members, if you're in a condominium association, figure out what kind of rule you need to get in place. And maybe, if you've been thinking about redoing your rules for a period of time and you just really hadn't gotten around to it, maybe now this is the motivation to do that rule and regulation update that you had been waiting on and include this provision in there. Other things that you need to consider immediately. A couple of years ago, the ombudsperson statute. Does anyone remember that? Anyone who's heard me speak, maybe heard me talk about that, got modified and changed. It applies to everyone. Common interest communities, homeowners associations, townhome associations, condominiums. And what it requires is that every association adopt an internal dispute resolution policy by January 1st, 2019. So you still have 10 months to do it, but get it in place. What does that mean? I like to refer to it as the reverse rules and regulations. So we know what rules and regulations are. It's where the association basically tells the homeowner you're violating this rule that we've set in place. The homeowner can file a request for a hearing. They can come in, have a hearing with the board. After the hearing, the board decides whether or not to issue a fine or not. The internal dispute is kind of the opposite. It's before the homeowner runs to the courthouse and files a lawsuit because the board is not following the act, its bylaws, its own regulations, the homeowner can initiate a complaint against the board, have that addressed by the board, and there are certain protocols and procedures in the statute that say it has to be responded to within a reasonable time. You have to give them a final file. You have to, do these things to allow the homeowner to be able to come and address the board. The thought behind it is that really is designed to avoid litigation. That before that person feels like, I'm just gonna run to the courthouse because the manager won't let me send anything to the board members and the board members won't let me talk at any meeting, this is going to be a requirement that you actually have to put that on and listen to that person. From what I've heard from the ombudsperson's office, and effective January 1st, 2017, there is an ombudsperson. She has told me what she has seen in the last 10 months mostly are self-managed association problems. So associations without professional management just, are doing it wrong because they don't know, or they're, a 6-unit association in the city of Chicago and 3 people serve on the board and they all got along when they were all living there, and now 2 tenants have come in and a couple other people and they're angry about it. Yes, Chris?
Just a real quick question. How was this ombudsperson selected?
So interesting. So, as we know, the state of Illinois is flush with money and has resources for everything. That was one of the big concerns. They wanted to always set up this ombudsperson's office, and everybody said, yeah, where are we gonna get the money? We're gonna have another office. Originally, they wanted it with the Attorney General's office. The Attorney General said absolutely not. Then they wanted it with the Secretary of State's office. The Secretary of State said absolutely not. So they went to the Department of Financial and Professional Regulations and said, it's gonna be at your office, and they said, okay. They said, conveniently enough, we already have an attorney on staff, so we're just gonna give her more work. So how was she selected? She was assistant counsel for the real estate related matters, and now she's also the ombudsperson. So she's been a bureaucrat in that department for a while, basically. So they didn't go out and create a new office, probably didn't even move her desk.
So you weren't advertising it on Craigslist?
No. I don't think you could see it there. So that's kind of 2017. And that's, before we get on to some of the new legislation, anybody have any questions about what we've discussed? Yes, sir.
Real quick, on this thing about preparing statements under GAAP that has to be done at year end, okay? Are there any exceptions to the rule that you have to do it prior to that, such as an attorney wants to see your financials, a court wants to see something, maybe there's some litigation with the owner? No exceptions to it,
No, those aren't accounting obligations under the act.
okay?
So, no. Anyone else? Yes, sir.
You said most of these apply to units over 100 plus.
That was only for the accounting. Everything else applies.
To across the board.
Yeah,
Okay, that's what
that was the yes, Tina.
I have an association where the pool and the pump house are separate from the major association, and they've requested a address list so that they can solicit the homeowners to buy pool bonds. Would that fall under commercial purpose, or is that kind of?
Is a member making that request?
Yes.
Okay.
The board are all members of that association.
So they want the names and addresses of the people so they can buy pool bonds for a
So
neighboring.
that they can send information out to everybody in the association about the pool bonds. I mean, so it kind of is commercial, but it's.
I would say, yeah, if you're soliciting, yes.
Okay, so the association probably shouldn't do that.
No.
Okay.
So that's where we are. Yes, ma'am.
All right, where on this first handout is the reference to what you just discussed about the ombudsman?
It's not on there. Because actually that statute was changed in 2016. So this is a kind of a reminder to you
Got it.
that what they did in 2016 is it was originally supposed to be in place by July 1st, 2017,
And now it's moved to.
and they moved it to January 1st, 2019.
Okay, thanks.
Okay, so sum up the bills. There are 5 bills that have been introduced to change those changes to Section 19 that I just talked to you about disclosing information. There are 3 bills that have been introduced to change manager licensing. There are 3 bills that have been introduced that deal with attorney's fees in collection proceedings. 1 bill that's term limits for common interest community board members. one bill about the disclosure of resales in condominium, or common interest communities, one bill clarifying the class of membership, one bill changing the GAAP accounting standards for condominiums. So we're all of 45 days in, 50 days into the new year, and we already have multiple changes. Talking to some state senators this weekend, they said, yeah, this is what happens. Sometimes we sign off on a bill, and then we start hearing from our constituents, and we say maybe there's a better way to approach this. So the changes to Section 19, the first one is really simple, and it's already actually got out of the Senate Judiciary Committee, and the reason why it got out is because the sponsor of the bill is the chair of the Senate Judiciary Committee. It will get to the Senate floor, and then it will go to the House. It's going to have a much more difficult time in the House. Where the last year, email addresses and telephone numbers were put in, Senate Bill 572 takes out email addresses and telephone numbers and leaves the rest of the statute intact. A lot of people are applauding that. A lot of people think that you should have that out of there. I personally think that it's going to have trouble in the House because the chair of the House Judiciary Committee is the person who put these in there. So we may have some warring factions going back and forth about those changes. There are, one of the bills introduced by the chair, the city of Chicago, through an alderman who was very, very, very angry about the changes, came up with an idea. And he said, okay, you changed the Condominium Property Act, I'm gonna change Chicago Municipal Ordinance. And where you said 10 business days, I'm gonna change it back to 30 days. And when you said email addresses, I'm gonna actually make it against the municipal ordinance to disclose email addresses to anyone. So basically, he was begging for a court fight because you were gonna put associations in a situation where somebody had to win and somebody had to lose. You weren't gonna be able to comply with both acts. So the playback then is that the legislature said, even if you're a home rule community, we're going to use our legislative power to say that on these two topics, we control and we're the final word, and you cannot use your home rule constitutional rights on that, which is permissible under the Illinois Constitution. So we'll see how that little battle plays out. One of the other bills that's been introduced by Senator Conley is changing the way the association can impose fines. And what it allows is the members for email addresses, telephone numbers, that type of private information to send the association an email or send the association communication and opt out. And if the person has opted out, then it cannot be disclosed. Or another bill has also would prohibit the board, the association, or any person working with the board from selling, distributing any of that information to another entity. So they're kind of dancing around what to do with this because they're getting a lot of feedback, especially the representatives in the city of Chicago who have high-density condominium buildings, about the way the legislature had approached this. Something's gonna happen this year because there's been a lot of articles and there's a lot of heat and there's been a lot of noise about this. I don't know which one of these 5 bills is going to end up advancing or what other modifications we might see. My guess, if it's anything like last year, whatever everyone agrees to and thinks is a great idea, that bill will be thrown in with 3 things that we don't like. And then it'll be the dare. There's an interesting bill that I haven't gotten an answer. In the Common Interest Community Association Act, it says, board members shall be elected for a term no longer than 4 years, comma, but officers and directors may succeed themselves. They want to take out the phrase, but officers and directors may succeed themselves, and say that succession shall be defined by the individual community instruments and not by the act. So we've written and said, who are all these people who want to serve on boards that are not getting on these boards because of the succession? And I haven't gotten that answer, because I said that's kind of uncommon to my experience. My experience is more along the lines of, oh, please don't quit the board this year. We really, really, really need somebody to stay on. Or would you be willing to be appointed to the board? Or we only have 3 board members this year, even though we're supposed to have 5 because we can't beg anyone else to go on. I hope they all show up so we can have a quorum and conduct any of our business. Nevertheless, there's this fear that people are succeeding themselves forever and ever and ever. And, you know, because as Mike pointed out earlier, the pay is awesome. So you really can't pass it up.
Yeah.
That's
my pay every year.
Yeah. That's tough math.
Everything's a 0.
One of the other changes, so last year a bill was introduced, as I talked about earlier, that said that they were gonna set a threshold for common interest communities that had to be at over $1,000 before you could initiate a collection proceeding. We had a chance to talk to the state senator, and she said the concern she had received from a constituent was that not only that they thought these amounts were going after, but they didn't know. They didn't know what the collection proceedings were. It was an association. They didn't know if it was monthly. They didn't know if it was annual. They didn't really have an understanding as to what could happen to them if they didn't pay their assessments. So I suggested to her, rather than imposing this arbitrary burden, and I kept telling her, I live in a homeowners association. My annual assessments are $50. You know how long it's gonna take to get to $1,000? 20 years of not paying assessments before they could initiate a collection proceeding against me. That's awesome. She said, okay, yeah, you're right. This is kind of an arbitrary number. So what they did is they suggested Senate Bill 928, changing the disclosure requirements. And if you have a collection policy, disclosing it if the buyer asks at the time of purchase. Disclosing whether the assessments are paid quarterly, annually, monthly. Most of your paid assessment letters have those. I've seen that. It's in there. But some associations don't always operate this way, and other associations don't have professional management. And providing them with whatever the late charges are. It's $25 a month, if it's 4% interest, and how that is applied. So that's what that bill is designed to do. Probably for most of your communities, it will change nothing because you're already disclosing most of that information on your paid assessment letters and certainly on your pre-disclosures. There's a really unique provision in both the Common Interest Act and the Condominium Property Act that says that the association shall have one class of membership. And now the Common Interest Act has a qualifier. It says unless the documents otherwise provide. The Condominium Property Act doesn't. So the genesis of that portion of the statute came from developers granting themselves, even post-turnover, well, I have 5 votes for every unit that I have, and you only have 1. So they turn the association over, because they'd have to do it within 3 years, but they would effectively control the association. So the legislature said that's not fair. One class of membership. Unfortunately, that was 20 some odd years ago, and in that period of time, people have taken it to mean different things. So somebody would say, oh, well, we have a rule for tenants that they must pay a $20 fee to register their pet, but you can't do that. That's 2 classes of membership. Well, we give preferential parking to people who are on owner-occupied property than we do to people who are investors. You can't do that. That's 2 classes of membership. Couldn't do anything because it was 2 classes of membership. So originally, it struck that. People didn't like that. So through negotiations, what it's been diluted to is that you can have classes of membership as it relates to parking, storage spaces, safety and security rules. If you're saying that we're going to treat on those specific items tenants different than people who are owner occupied, remember this is only condominiums, then it would be permissible. Common Interest Act, they cut it back out. About the gap accounting, there's a bill pending that's going to still get it to 100 units for condominiums, but they're going to start at a higher number. So the way the bill has been changed is that it's going to start at 200 units. After a year, it's going to go down to 175 units. After another year, it's going to go down to 135 units. After another year, it's going to go down to 100 to tier it in. I'm not sure why this came about. I'm not sure who cares about it. My recommendation is if you're going to be, if you have 136 units, you should probably get to it quicker rather than wait 2 years. But that's what the statute changed. There is, yes, ma'am.
Would you be in violation of that if you had separate assessments for separate units? Separate assessment amounts monthly?
No.
That's not a different class?
No, you should if you're a condominium because there should be percentages of ownership. Everything's built on the percentages. And even if you're a common interest community, if your documents provide that different neighborhoods or different areas or different places are receiving different services and they're specifically allow you to assess for those individual services, even in some common interest communities, there can be different amounts that people pay on a monthly basis. One bill, it doesn't really say homeowners associations and it doesn't say condominium associations, but I think it has enough in it to really help, is the Assistance and Service Animal Integrity Act. It will require providing verifiable certified information regarding the disability of the animal and a certification from a medical professional. Now, right now, it says that that's what must be provided to landlords, but it criminalizes providing any of that information that's not false, or that is false. And if you're on this form falsifying your disability, that's a felony under the statute as proposed. So I don't know where this bill's gonna go. There's probably some issues with federal law, that it's not going to be totally in compliance with federal law. It's probably gonna have some HIPAA issues because they're gonna mandate federal certifications when HIPAA would otherwise provide that you don't have to turn that over. Nevertheless, it's starting the conversation that we're starting to see in Illinois and other states, that there's a little bit of abuse going on with emotional support animals. Yes, ma'am?
Okay, that was my question, because what it says here, the bill says is service animal. There's a difference between a service animal and an emotional support.
Right, and it also deals with service and assistance animals.
And-
Right.
Okay.
And then it goes on to reference, not define, but reference the Fair Housing Act, which is what applies to condominium associations in dealing with the emotional support animal or assistance animal. I think the Fair Housing Act actually uses the word assistance animal. I think emotional support animal is kind of something that's just culturally we've adopted as a term. But there are more and more abuses going on about this, and there are communities that are dealing with it where they have absolute prohibitions against pets, and then lo and behold, now they have pets there. Some of it's legitimate. And where I personally think we're going to ultimately see the pushback on this is for people who actually represent disabled people. Because they're going to say, we're getting cast in the light of being liars and cheaters and everything else, but we actually have people who we're working with who are legitimately disabled, who are actually, getting what they need to enjoy their housing from this animal. And the person who decides that they just really want 3 dogs, even though their rules say they can only have 1, and went online, and if you haven't seen this already, do a Google search, you can get yourself an emotional support animal. I mean, you can get yourself an unknown emotional support ferret by the end of the night. For $50, you'll get a certification, and there is a licensed therapist, typically, this is the new wrinkle, sending it to people in Illinois, licensed in maybe Missouri, but living in Michigan. And it won't say what the specific disability is anymore, because I have to imagine one of these therapists actually had some licensing issues because somebody went to them and said, how are you diagnosing somebody that you've absolutely never seen? Because that probably violates a lot of medical professionals' issues. So they just say the person falls within the definition of a disabled person without providing their specific disability. This is going to come to a head either in the federal courts or through the legislature because it's becoming a problem. And I'm sure none of those people want to sit for a deposition. Most of the issues that I think landlords are seeing now, especially commercial landlords, I think it more affects community associations. Commercial landlords say, yeah, I know it's a no-pet building, but I don't live there. This person showed up with a note and everything else. Do I really want to be involved in a federal lawsuit or let them have their stupid dog for 6 months? Why do I care? But community associations, for some of them, I mean, it's really changing the nature of it. And I think where we're eventually going to see it is with the competing disability, where somebody's going to say, I bought this unit in this no-pet building because I'm highly allergic to cats or highly allergic to dogs or something along those lines, and I actually have a disability that I need accommodated because of my allergies, and somebody else is going to come in and say, well, I have anxiety, and therefore I need this dog to help me get through my daily life and daily existence. And I was at a legal seminar earlier this month, and when that topic came up to the person who was presenting on this very topic, he said, choose the one that you'd more likely to see, you'd more rather see as the plaintiff. And somebody said, what do you mean by that? Like, figure out which ones are going to be really, 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 really nasty to you, accommodate that person and tell the other person they can't have whatever they want. But at some point, it's gonna happen. I mean, the reality is, at some point, it's gonna happen. I mean, I think the airlines are starting to experience it now, where people are coming in with dogs and somebody else is saying, I'm highly allergic to dogs, I can't sit here, or the person with the peacock, yeah. You know, the stories like that really start to change the way people approach it. There was a New Yorker magazine article a couple of years back where a person actually brought multiple different animals to just see how many different facilities she could get into with things like chicken or a boa constrictor and something like that. She was never turned away. Even though, she had made up tags, like for the boa constrictor. It was a great story where she put it on there like, this is my emotional support boa constrictor. Look, it's got its own like little jacket that it's wearing. So those are some bills that we're monitoring now in 2018. If you are not a member or haven't signed up or haven't gotten a login to CAI, this information comes out when we do need responses, when we need people to call their legislators, when we need people to write their state senators, when we need people to write their representatives. One of the bills that's pending regarding attorney's fees, regarding condominiums, would require, listen carefully, each condominium association to conduct a hearing before commencing collection of unpaid assessments. I'm not sure what that hearing is involved. You haven't paid 3 months of assessments. I know, but blah, 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 blah. Okay. Well, Condominium Property Act says the association can't forbear assessments, and the Condominium Property Act says the board has a duty to collect assessments. So how are we having a hearing to hear what it is? Again, the theory is that my office is just sitting there waiting for these delinquent accounts to get turned over so we can charge thousands and thousands of dollars against these people. And that if they just had a chance to have this hearing before the board, you would be able to work out some really other great way of having them come up with the money and pay than we are. But that's not gonna happen. That's not the reality. It would be really, really, really problematic for most associations because you're just gonna put yourself 30 days more behind. And what happens in the end? That the people who pay their bills on a timely basis suffer for the people who've decided to fight against it. And it'll harm associations, it'll raise your legal fees, and it's not going to be helpful. But the one angry homeowner now is gonna get their hearing to come in and tell you that the reason why they haven't paid their last 9 months of assessments is because somebody didn't shovel their sidewalk in December. And you're gonna say what? Turn it over. That's it. It also doesn't define when the hearing shall be, who shall hold the hearing. I said, okay, great, these will be 7 o'clock in my office in the morning. I don't know. I hope the bill doesn't make it. It hasn't really even been giving a hearing date in committee. We are working and talking to the sponsor saying that there are already mechanisms in the law. We have to send out a 30-day demand letter. That 30-day demand letter is a statutory letter. It must comply with the Forcible Entry and Detainer Act. The owner has 30 days to make that current. Also, federal law under the Fair Debt Collection Practices Act grants anybody receiving that letter the ability to dispute the validity of that debt and requires the debt collector, me, to send out supporting information about any of that documentation, or my office is subject to federal litigation against it. So I don't know how many more days and how much more time people have to get to pay their assessments on time, but it's not going to be beneficial to condominium associations.
You think that, getting back to that other one, where you can only be on the board for a certain length of time, do you think that maybe there's somebody kind of like the Baum situation where the guy's a lawyer and he says, you know, if we get that enacted and then nobody wants to be on the board, I'll just quit paying my dues?
Here's what I think happened. I think somebody tried to propose an amendment to their common interest communities bylaws to put term limits into their bylaws. And there's a couple communities I represent that actually have term limits in their bylaws. And somebody told them, you can't do that in your bylaws because it violates the Common Interest Community Association Act, because the Common Interest Community Association Act says you may succeed yourself. So those terms are in conflict, so your term limit in your bylaws is invalid. I would not share that opinion, because it says may, not shall succeed themselves. So they may succeed themselves, but it doesn't require them to. And I would think that term limits are valid if they're in the bylaws. Now all they're basically saying is, put it in your bylaws what you're gonna do with succession. So, again, it's one of those imaginary problems. That somehow there's, all this group of people out there clamoring to be on the board, but they just can't get on. Again, there's also this thing called an election, from what I understand, where if actually more people want you on the board than the people who are currently on the board, they'll actually vote for you and put you on the board. But, yeah, so, and the irony of asking the Illinois State Legislature to impose term limits on associations, that kind of made me smile when I thought about that concept too.
We're in the middle of changing the declarations and bylaws to be in compliance with all of this going back a few years.
Right.
Plus this new stuff. What is the source of the language that we're trying to put into our stuff? Are we copying the exact language from the?
Well, the Condominium Property Act, which I think in the last 3 months I've come to the conclusion is a giant mess, to be honest with you, because it's a statute that, condominium associations are what we refer to as a creature of statute. They don't exist at what's known as common law. Common law, you own property, I own property, we all own property, the way it's separately deeded, we get our surveys and everything like that. And the idea that we can own airspace under a condominium and collectively own a percentage of the common elements was kind of unique. So in 1968, the Illinois Condominium Property Act is created after Florida and after New York. And then it keeps getting changed, but it's cobbled together changes. It's never been looked at again since 1968 as a unified piece of legislation that said, how are we doing this? One of the sections that they're thinking about introducing this year is section 18.11, which means there's a section 18, 18.1, 18.2, 18.3, 18.11. There's a section 9, there's a section 9.1, there's a section 9.2, there's a section 34. Now, why there's a section 18.11 and not a section 35, I'm not really sure. But the act is kind of really this weird cobbled together piece of legislation. Then in 2010, they enact the Common Interest Community Association Act for common interest communities that has some of the things of the Condominium Property Act and some of the things that aren't. And it's kind of like a condominium, but then they change that right away and make sure that master associations, which are in another part of the Condominium Property Act, aren't included in there anymore, but are back to section 18.5. I think the acts need a uniform revision. There's a Uniform Common Interest Community Association Act that's put out by the Uniform Board of Law Reviews, and I think has been adopted in parts by about 20 other different states right now, that say, you're all more alike than different. The way that you're different, we can deal with individually, but your governance is the same. Your board elections are the same. Everything should be the same, and we shouldn't be guessing of, well, I did it this way because it was a townhome. No, it's not really a townhome. It looks like a townhome, but it's a condominium because it says that it's submitted to the act. So that's what I think. So what do you use? You use a lawyer, because there are mays in the act. There are shalls in the act. There are mandates in the act. There are portions of the act that say, unless your documents otherwise provide. So it's not consistent. Section 18 of the act says the bylaws shall provide. That's the one section that I think you can go through and say, we should have everything that section 18 has in it. Section 2 is the definitions. Your governing documents should probably read like section 2, which is the definitions of various areas. But it doesn't define everything. It doesn't define parking garage, doesn't define parking spaces, doesn't define designated parking spaces or limited common element parking spaces. So it's incomplete. And it's always going to be incomplete, even under the best provision, because every building's not the same. So how does that help you? It doesn't. I'm sorry. How does it help you?
So we had our declarations and bylaws reviewed by your office, and we got a letter saying these are the things that should be changed or needed.
Right.
All we do is write a letter to your office and say, do what you recommended.
If you're just going for a compliance document, yes. If you decide as a board of directors that you're going to undertake substantive changes to your governing documents, which are going to be voted on by the homeowners, then you're gonna have to give us a little more direction than that, because I don't know which substantive changes you want. You might change your maintenance obligations, you might enact a leasing restriction. And real quick, I know we have till 8 o'clock, and Mike asked me to talk about 2 other issues, and I'm gonna talk about them quick, and then we'll do some question and answer, if that's okay. Mike just asked me to talk about collections. Don't forget about collections. Collections are very important. If you are not regularly reviewing your delinquency reports, you should be. There is no good reason why you should have people who are delinquent at your association. The state of Illinois has provided us with a wonderful mechanism to be able to collect assessments. It's efficient. Unless somebody's in their multiple bankruptcy and in foreclosure and something else strange and they died, we're probably going to figure out a way to be able to collect that assessments. Don't ignore them. Foreclosure, that doesn't mean that they stop paying their assessments. Bankruptcy, that doesn't mean those assessments aren't owed. While somebody may no longer have a personal obligation to pay assessments, the lien against their unit remains, and they have an obligation going forward. So don't take those things as answers for collection of assessments. You should be collecting your assessments. Anybody who's a condominium and wants to be FHA approved, Federal Housing Authority said if you're more than 15% delinquent, you're not getting FHA approved. Really, lenders are asking their office now, even if you're not in the condominium association, lenders are asking as part of their questionnaires, what's the delinquency rate at the association? Why? Because they don't want to loan to somebody who maybe only has $5 extra a month and find out that the delinquencies at the association are 35%, because then they know if there's a major project coming, it's coming out of their owner's pocket, not these other people who aren't paying. So these are things you should always be looking at. It shouldn't just be an annual thing. Unless you have annual assessments. If you have annual assessments, fine, look at your delinquencies once a year. Otherwise, you should be on top of this, and this should be part of your regular management review of the delinquencies. Real quick, leasing. How many associations have some form of a leasing restriction in their documents? Okay. How many who don't want one? It's a hot topic. It's always a hot topic. It's been a hot topic for years. And it changes for community to community. There are some financial reasons to have a leasing cap or a leasing restriction. Lenders generally, for condominiums and townhomes, don't like to see those associations more than 30% investor. They certainly don't like to see them above 50%. If you're above 50%, you probably won't be able to get conventional financing. So once you get over 50%, probably the only people who can buy the units that go up for sale are people who have the cash and probably aren't going to live there anyway. So it kind of becomes one of these stumbling blocks. So if you see your association increasing its rentals and you really feel like this could quickly escalate, you might want to consider either some kind of a cap or a leasing restriction. Be aware, my recommendation, before you undertake the drafting of any of those things, get the pulse of your community. Because like I said, I joked at the beginning, increasing rates 150%, go to a hotly contested meeting where a leasing restriction is being discussed. People get loud, people get angry, people get personal. People who've lived in their unit for 15 years come in and say, you're taking my rights away from me. Haven't you lived there for 15 years? Yes, but what if I eventually want to lease it out and buy it? Now you're going to take that away from me. Okay, do you see that as a likelihood? No, but I'm still angry about it and want to yell. So know what if it's not going to be feasible, if 60% of the people come back and say absolutely not, then don't waste your time. Then that's what's going to happen. But if most of the people say we'd be interested in considering something, first of all, figure out what percentage of people you need to pass. Then figure out how many investors you have out there. If you need 2/3 to pass and you're already 30% investor, you're probably not passing that amendment. Unless you're going to grandfather them in forever and ever and ever and ever. And even then, somebody better go and talk to these investors and explain to them what's going on, because most of the time they're still going to say no. So think about that going forward. And with that, does anyone else have any questions on anything that we've talked about or other things? Yes, Bonnie.
What happens if nobody wants to be on the board?
Hold on. You have to ask it a different way. What happens if nobody is on the board or nobody wants to be on the board? I think nobody, there's probably a lot of communities where most people don't want to be on the board. They still show up and do it, though. So let's say nobody, for whatever reason, nobody is on the board. Eventually, no one will pay the bills. Eventually, no one will do any upkeep, no one will collect assessments, no one will pay assessments, and an association theoretically could go into receivership. That's usually only going to happen in those types of buildings that are 70 or 80% disinterested investors, where they don't want to serve on the board, they don't care, and they don't care if it goes into receivership because they just want to collect a rent check every month. But most communities where people live there, it's more about arm twisting, it's more about begging, it's more about maybe going through some periods of time where you're supposed to have 5 board members, but you really only have 3, and you're gonna see if you can get another person involved. Again, it's the same story at every association. Yes, sir?
How do you go about getting all these rules and regs, all the things you talk about, paperwork-wise, copies of all the stuff you talked about?
How do you get copies of it?
Yeah.
Well, if you're a member of an association, you can request to inspect any of those records from management or from the association.
Well, I'm one of the board members. I don't know who has it all. My question is, how do you get?
Call your property manager first is what I would do. I mean, they should be able to get you probably all that information. I know with Baum, you guys have almost everything on their website even. So most of this stuff is accessible to even me, just going onto Baum's website and seeing rules and regulations, declaration, bylaws, amendments. Some association even have their minutes up there, their policies. So a lot of that's already on there. What association are you at?
Arbor 40.
Then you need to contact your property manager and tell them that you need it. And if they won't give it to you, you need to call Scott Millard and tell him that you're not getting it.
Who's Scott Miller?
He's in charge of the property managers at Hillcrest. And tell him I said so.
Jose to the front desk, please. Jose to the front desk.
Yes, sir.
Okay, we have 20 units in our association.
Okay.
And it's very hard to get board members.
How many board members are you supposed to have?
5.
Okay.
So can I run it with 3?
Yes. That's the General Not-for-Profit Corporation Act. That's the basement at 3.
Okay.
Yes, ma'am.
One question that keeps coming up every time we look at delinquencies is, okay, almost everybody misses a month.
Yeah.
So, month late, no big deal for a month. How many times after the first month should we start legal proceedings or whatever you wanna call it, letters, what have you?
Let me go backwards on that a little bit, okay? Or actually, I'll go forward with it, but you have to see where this goes. So 1 month, okay. My personal opinion is 60 days. And why 60 days? Because at 60 days, let's say you look at it, and it's really not on day 60, but it ends up being day 65, day 66 by the time you talk about it. And you tell management, you know what, we should really turn this over for collection. It's 2 months, it hasn't been paid. Now I'm gonna send out a statutory demand letter. That's gonna give them another 30 days. Now we're 3 months, okay? In that statutory demand letter, we include the attorney's fees for title search, bankruptcy search, foreclosure search, and the legal fees that are included in there. If somebody's 3 months behind, most of the time, they will find a way to come up with some kind of a payment plan with that 3 months. If you let it go longer, you're actually making it harder on the person. If you send them something and your assessments are $300 a month, and it's 9 months or 10 months, and they say, now you owe $3,000 of unpaid assessments plus $200 in legal fees, that's gonna go in the pile of a lot of other things I'm gonna ignore until I can't ignore it anymore. But even after 3 months now, the letter goes out, and let's say nobody's paid, our office has a procedure where we contact management saying, we didn't get a payment, did you get a payment? They said, no, we didn't get a payment. Okay, you know what, print it off, file the lawsuit. Couple of days lag in there, we get the lawsuit on file. Let's say we're even really timely. The lawsuit's gonna have a return date of somewhere between 20 and 28 days before we get into court. Now we're 4 months, maybe 5 months between some of that lag time. If we get service right away and get into court the very first time and get a judgment for that amount, the statute requires it stayed 60 days. Now we're another 60 days down the road. And that's best case scenario, what I'm describing to you. If we don't get service, it could be another 14 days. If the person comes in and demands a trial, it could be another 30 days. So now we're 7 months, 8 months. Let's say they still don't take it seriously and they've ignored everything. And so we place that order that stayed for 60 days with the sheriff to come out there and conduct an eviction or at least scare the heck out of them. Now we're 9 months. By that point in time, the person, between the legal fees, between 9 months of assessments, they're struggling. But we still sometimes get those payments. They show up, they swear at people on my staff, they yell at Mike, they yell at Tina, but lo and behold, the money comes from somewhere. And at that point, we're saying it's cash or it's certified funds. Otherwise, we're not taking anything else. So that's 9 months in the best case scenario. If you're waiting 6 months before you're going, now you're over a year and a half of delinquent assessments. That's too long in my opinion. So that's why 61 days is kind of my recommendation. Yes, ma'am.
There's nothing that says you can't. If you have Baum as your management firm, the board gets a copy of financials every month, and one of those pages in the financials says who maybe didn't pay their assessment. If you see that and I should knock on wood, we are very lucky. We very rarely have anybody who doesn't pay. But if we see that someone doesn't pay, it's okay to have them just send a reminder letter after 30 days.
Yep. Sometimes those get paid and sometimes they don't. What I would recommend for most associations, if you're having issues with collection and the way they're proceeding, adopt a collection policy.
Exactly.
Give that to your manager, say this is what it is, and it's blind. If it's my next door neighbor, if it's the board president, it doesn't matter. If it's this many days, we're doing this. If it's this many days, we're going after them this way. And this is the payment plan we're willing to accept if they're delinquent. And here's how much we want down. And if they're in foreclosure, we want you to proceed this way. And if they're in bankruptcy, we want you to proceed this way.
One other question is we have, if they, let's say they're over their 30, they pay, they're 30 days late now, and we assess them a late charge of
Right.
$15. Okay, the payment comes in, can we, take that $15 late fee out of their assessment?
That's really an accounting function, and I don't mean to be obtuse about this. So you're assuming that they haven't paid the entire amount.
We have one individual, there's always one, that is sporadically late.
Right. Well, you can keep assessing them the late fee for every month that they are late.
So then what do we do with all those late fees? We wait until they sell the unit? and collect?
Usually. Yeah, we're not gonna file a lawsuit for 9 months of late fees at $15. That's just, a judge is gonna laugh us out of a courtroom for that. But they'll eventually pay. But remember, the late fees can be on delinquent payments. Okay, there is a case where, and the scenario was somebody missed the month of January, they got fined for a late fee of $25, then they paid February, March, April, May, June, July, and they were getting hit $25 a month for every single month. And what the court said is they weren't late in those other months. They were late only in this month. So you have to be careful with the way you account for some of those things. And that's why we're kind of very particular at our office when we see account statements. If we have an issue with any of those things, or we think we're not going to be able to recover these amounts eventually before a judge, we go back to management and say, we need to make these corrections before we even send out this demand letter to get the account statement in a way where we know if we're sending it out, we're getting those things. So one of the things we do is if somebody's got fines on the account, we send back a letter to management saying, great, there's fines on the account. Please send us the letters that you sent to the homeowner telling them about the fines. Then we actually look at the rules and regulations and make sure it's actually something you can fine somebody for. If there's a chargeback on the account, we'll say, great, send us the invoices so we can be able to substantiate those charges on the account. Because we don't want that letter going out and then having that homeowner be able to say, well, I wasn't fined for that, that never happened, I never got notice for that, I never got a chargeback. Because then we're gonna go into months and months and months of going back and forth, back and forth. That gets done up front. And again, having a collection procedure in place settles a lot of these back and forth issues that involve the board and management. The management has an instruction as to how they need to proceed on collection, and they're supposed to do it then. Yes, Dave?
When you go in front of a judge for a delinquency case, does the judge prioritize the days, the age of it, over the dollars? I mean, if there's three $15 late fees, and somebody told me, let's go to court over this, you
Yeah.
don't really wanna go in for
No.
$45.
Not doing that.
It is 3 or 4 months old, but it's
Right.
only $45.
So where we've seen that sometimes is, thankfully, I've elevated myself to the point in my practice where I don't have to go into court on collection cases anymore. But when I used to, quite frequently, sometimes we'd go into court on an association where they had an annual assessment of $250. And the judge would look at you and say, $500? Really? You're in here for $500? And I would say to the judge, Judge, that represents 24 months that this person has ignored paying their obligations. And the judge would say, okay, you're entitled to it. Now, other times, so it can go back and forth either way. So the judge will look at both. But the case law is kind of developed in the state of Illinois where it's really simple. Did you pay or did you not pay? And that's really the inquiry. What happens when they did pay or they paid something, or by the time we got to trial because they went and made a payment, they didn't want to pay the attorney's fees, what happens is the attorney's fees get cut. That's where the judges exact that. So if you're for whatever reason in court, and by the time you show up for the day of trial, it's only $175 because they still owe on the account. Now, we recommend management don't accept partial payments when we're already filed a case, so we can recover everything for the association. The judge will say, okay, fine, now we're here, it's the fourth time up, how much do you have in attorney's fees? Well, we have $900 in attorney's fees and $236 in court costs, and they owe $175. The judge goes, oh, okay, well, that's fine, I'm gonna exercise my discretion, and I'm gonna award you $250 in attorney's fees, $175 of the unpaid assessments, and all of the costs. The judge smiles and nods at our office, and we smile and nod back knowingly, because we know we'll be back there next week. Not appealing that case. Yes, sir.
I have annual assessments in a homeowners association, and they're $500 a year.
Right.
So I have some residents that are way over since I've just taken over. Do I need to have the rules and regulations amended, or can I have Baum put in a general rule that states, you know, you'll get 30 days, then it's a late fee, 30 days after that, you're going to collections, or does it have to be amended in the actual, like, rules and regulations?
It doesn't need to be in the declaration or bylaws. If you're going to assess a late fee, it has to be in a rule and regulation. The decision as to when to turn accounts over to collection does not have to be written in either a rule or the declaration or a bylaw. Once somebody's delinquent, you can instruct Baum to turn them over for collection.
I guess what I want to have is so that they read it, almost as a scare tactic, because they're $500 a year and I want it to like go right away, so they pay. I can't be having waiting.
When do you tell them that they have to have them paid by?
April 1st is when they're due, so then they get all of April, and then it's a $50 late fee.
Yeah.
And
then it should be
people that don't pay for a year or two.
And then it should be another $50 late fee at the end of at the end of July, then another $50 late fee.
And some just ignore it. You know,
Okay.
I wanna change it, but I also wanna just be able to.
No, then maybe you should include in your rules and regulations exactly what the procedure that you're going to have,
Okay.
just so it can be communicated to the homeowners.
Cause the old board just passed like a rule with the late fees.
Okay?
I don't know if we can just amend that.
I don't even know if you need to do that. If the late fees are already in there, then what I would do is I would just adapt by resolution a collection policy, and then I would have that collection policy sent out to all the homeowners. So you don't have to do it as a rule and regulation because it's just a collection policy that's a resolution by the board. And then you let the homeowners know, we adopted this. And you don't have to let them know legally, you're just letting them know, hopefully as like you said, a scare tactic or a motivator.
How often do you run into evictions in homeowners associations? That's where I'm at right now with one.
I'm at I would say, I'll give you kind of a broader spectrum. Of the demand letters that we send out, we probably only initiate suit on 30% of those demand letters. We probably get about 70% of the people to either enter some kind of payment plan or pay it outright on the demand letters. Of those 30% that are filed, we probably get agreed orders on 2/3 of those, where people in court will recognize that they need to pay this. And then of that last remaining 10%, I would say 5% of those people pay when the sheriff tacks the note up on their door that they're going to be evicted. So I would say it's it's maybe 5%, Mike, I don't know. Tina, any idea how many evictions you guys conducted last year? 5%? 5%? So 5% of the people probably actually ever get evicted or
Because
less.
my old board waited a little too long, so now they've just ignored
And
everything.
annual assessment, homeowners associations, it's probably closer to 1%.
I'm just curious, because I'm as far as like a stay date, and they've ignored it, don't go to court, and it's not bankruptcy or foreclosure, so that's about where I'm at.
You know, Mike and I were joking about this earlier. Some communities that run into delinquency problems, man, you conduct an eviction and the sheriff goes out there and everything gets moved out on the street. Lo and behold, everybody's calling up the management company. Am I current on my assessments? Am I current on my assessments? I want to make sure I don't owe anything. Because they're thinking, I don't want that to happen to me. That sometimes is one of the best collection methods to have that happen.
I mean, it's one of those things where we're in a tough spot, you don't want to have to do it, but I don't have the tolerance for it, so.
I understand.
We set it up 30, 60, 90.
Yeah.
And our manager, he notifies, I'm the president, he notifies me if somebody's late. I said, send them a letter. He sends them a letter. If it goes to the following month, 60 days, it goes to your office, and you send them a letter, and at
Mine's not
90
as
days,
friendly.
we're in court. I mean, it's, you know,
Yeah, it should work like a machine. It really shouldn't be something that the board should have to work that hard to consider. Folks, we're a little after 8 o'clock. Thank you all for your attention. Thank you for coming.